How y'all doing today? I'm here with significant paperwork. You can see here, and what I'm trying to do is basically show the people and powers that be of the history. And history is one thing you can't run from, and there's various secrets out here that need to be uncovered. I have been affected by all of this here, and I'm gonna tell you how I was affected by all of this here. But what we have to do is scratch beneath the surface, and everybody don't forget is to know your history, because your history is gonna tell a lot of tales on where things are going. First and foremost, I have here documentation on 3 individuals, which are 3 pillars to, I guess, the community here in Berkshire County and Pittsfield. One is Justice Spina on the SJC. He's also a Superior Court judge here in Pittsfield. Also was a city solicitor here in Pittsfield. I just want y'all to get a little clear look at his face so you can see who you are and who you're dealing with. And it says here on a piece of paper that, he was a justice. It says here on this paper, Francis X. Spina was a justice of the Massachusetts Supreme Judicial Court and was nominated by the court by Republican Governor Paul Cellucci in September 1999 and assumed office on October 14th, 1999. He retired on August 12th, 2016, ahead of reaching the mandatory retirement age of 70. He was succeeded on the court by Frank M. Gaziano. This guy has a lot of credentials. He's one of the top judges in the state at one time. You also have another individual here. He's a justice, and I think he's the top justice in this county right now. So Daniel A. Ford. Don't have his picture here, but you can Google him. You can look him up. Daniel A. Ford is an associate justice of the Massachusetts Superior Courts. He was nominated to the court by former Governor Michael Dukakis in 1989. Ford may serve on the court until he turns the mandatory retirement age of 70. But the scratch beneath the surface with Daniel A. Ford, and I'm going to show you a long history of Massachusetts, because Massachusetts used to have, if you ever wondered, Massachusetts doesn't have any state prison facilities in Western Massachusetts, but they did a long time ago, and they got closed down. There's a lot of history in that and how history repeats itself, and also dealing with Daniel L. Ford and the Commonwealth versus Bernard Barron. And if you look into that case, you'll see the same things that happened from there at that time, and you go back to 1959 to MCI Monroe, which was a camp, and it's the same things. It's hysteria, and it's kind of crazy. And it's actually the same thing that got Michael Dukakis, hit so he didn't win the election against George Bush. Everybody remember the issue with Willie Horton. So, something happened in 1959 where they should have been on point with having perimeter security on these prisons and facilities, but they didn't do it. And it happened again with Willie Horton. It's like, why didn't they correct it the first time? But anyway, we have the third person here, which is John A. Agostini. I had a conversation with him the other day. At a men inclined, sometimes you got to sit back and talk to the devil to understand where they at. But he's telling me, straight told me to my face in front of clerks and everything, that, nobody's going to accept responsibility. They're not going to deal with the situation at hand, dealing with anything at that point, even the Amherst drug lab scandal. But it says here, John A. Agostini is an associate justice for the Superior Court in Massachusetts. He was also appointed to the bench in 2002 by Governor Jane M. Swift. His term expires in 2023 when he reaches the mandatory minimum age of 70 years old. Yeah, we have a lot of articles here about a lot of people here and pillars and things of that nature. What I want to bring up first is Francis A. Spina, this guy right here. I want to bring up him first because Francis A. Spina was also, and it says right here, if you can read it, Justice Spina graduated from Amherst College and Boston College Law School. He worked for Western Massachusetts Legal Services and then as assistant city solicitor in Pittsfield, Massachusetts from 1975 to 1977. Francis X. Spina went on from that From 83 to 93, he was a partner in Reeder, Wayland, and Spina. And then Katz, LaPonte, and Spina. He was appointed to the Superior Court, 93, 97, put to the Appeals Court. Then the SJC by 99 by, again, Paul Cellucci. And then he retired. The thing I'm getting at about is that from 75 to 79, now I'm going to give you how the criminal justice system works and the tool and mechanism they do to keep job security and to keep minorities down. And the thing is that they said back in the day, hey, if you want to keep a black person dumb, and all the knowledge, put it in a book, because we don't read. The first thing you have to do is get knowledgeable first about your environment. Reading is nothing. Reading means nothing if you can't apply it to the everyday world. You have to actually go through these things physically to understand what you're reading and apply it to life. By that time, Spina implemented from this company, MPI. At the time, I think this is the Chief Peter F. Roddy. I think he's a retired police officer. But Spina implemented MPI policies at the time, dealing with the observance of privilege of the law and dealing with things of that nature and constitutional rights. Certain things are supposed to be done. But when he amended by his own favor that policy from MPI, it was state and federally funded at the time. MPI lost their state and federal funding in 1979, and then they became if you could read here, I don't know if you can read it, a 501c3 nonprofit organization. Okay? Once they do that, they're not a state agency anymore. Now, even dealing with that, I have paperwork here to put that on there about state agencies and rulemaking policies and power and things of that nature and what it should go to. And just give me a second here. Now, this is here in Massachusetts. Observance of rules of privilege, basically by law. And here it's dealing with the Massachusetts Administrative Procedure Act and the law and practices and the agency proceedings and how these matters are supposed to be handled when conducting in accordance to things to, I can't say hinder, but it's going to affect our constitutional rights. You have to make people aware they're supposed to vote. I searched the Pittsfield City Charter going back to the 1800s. There's not a vote on the policy from MPI getting in and enacted. The people weren't aware. And it says right here on this piece of paper that some state administrative agencies are, however, required by statute. Usually they're enabling organic acts to conduct other adjudications by observing the same formal rules of evidence that will prevail in a trial or civil action in the courts of Massachusetts. In addition, state administrative agencies may bind themselves generally through agency rulemaking and adhere to some of all the formal judicial rules of evidence. State administrative agencies which so bind themselves must then adhere to the formal judicial rules of evidence in the conduct of their adjudicatory proceedings. Now, if you have understanding with that, that's them, even at the end of the day, have to follow the rules and the guidelines of the courts, because then again, it comes back to our liberties and our rights. Okay, I'm going to read something else to you here. That is outweighed in a whole different light. The rules of privilege are united by one common objective. They are designed to protect and safeguard the interests or relationships which have been determined to be of such overriding social significance and importance as they overcome and outweigh competing social demands for the production of evidentiary data and information. State administrative agencies, just as courts themselves, may observe with appropriate deference and respect all legally cognizable privileges. And it keeps going on from there. This is 38 Mass Practice, Administrative Law and Practice, subsection 271. And you can look this up on Westlaw. You can look it on LexisNexis. This is the written law. This is the written law, mind you. It's the written law. Another issue I'm getting at, because it's getting to searches and seizures. I just want to put you on the principles of what it is. This is Article 14 of the Massachusetts Declaration of Rights, freedom from unreasonable searches and seizures and warrants. Every subject has a right to be secure from all unreasonable searches and seizures of his person, his house, his papers, and all his possessions. All warrants, therefore, are contrary to his right if the cause or foundation of them not to be previously supported by oath or affirmation, and if the order of the warrant to a civil officer to make such search is suspected places, or to arrest one or more suspected persons, or to seize their property, be not accompanied with a special designation of the persons or objects of the search, arrest, or seizure. And no warrant ought to be issued but in case with the formalities prescribed by the law. Now, Article 14 is the predecessor to the United States Constitution, Amendment 4, searches and seizures. Just a watered down version of it. You got to remember the Revolutionary War, tired of them being searched and seized and hiding these dudes in the quarter and they taking their goods and seizing their goods. Ring a bell? You know? So from that situation there, our rights in Massachusetts are more stringent. They're more protected. They're supposed to be more protected by the Constitution, but it doesn't seem so. I have something else here, which is, again, administration of the government, laws relating to state officers, state administrative agencies. And this is here dealing with city charters and things of this nature, what's supposed to happen. Section 2, a public hearing is required prior to the adoption, amendment, or repeal of any regulation. Violation of a regulation is punishable by fine or imprisonment. A public hearing is required by the enabling legislation of the agency or by another law. Public hearing is required as a matter of constitutional right. There it goes again. Like if it comes to them affecting anything to do with your constitutional rights, you're supposed to be able to vote on it. Now, like I said, I went back to the 1800s and searched Pittsfield records to see if they voted on anything in the 70s. I went back to the 1800s to see about any policy which is not in there. But I went back to the 70s in the time with Spina. And when he enacted that in between 75 and 77, Francis X. Spina did not hold a public hearing. The city council members of Pittsfield did not hold a public hearing to let people know about searches and seizures or inventory searches to come to their vehicles. When they come to their vehicles, they say, hey, you can just lock them up and tow them away. We don't need you to search. We're good. They didn't even give them that opportunity. That was usually the precursor, I want you to understand, to stop and frisk, because it has to be written before these people take advantage of what is written. So I want you to understand where this is going. They laid the foundation for the stop and frisk to happen. I want you to understand where I'm going with this, and I want you to understand where they violate your laws and all of this stuff I have right here. All of this stuff, it's all public record. All public record right here. Okay? So we got that out the way. Oh, yeah, we can go back here. Prior to adoption, amendment, or repeal of any regulation as to which a public hearing is required, an agency shall hold a public hearing with the time specified by any law, or in no time is specified, then at least 21 days prior to the date of the public hearing, the agency shall give notice of such hearing by publishing a notice of such hearing in such manner as is specified by any law. That was not done. If in no manner is specified, then such newspapers and, where appropriate, in such trade, industry, professional publications as the agency may select. B, notifying any person to whom specific notice must be given, which would be the people of Pittsfield. The best way to notify everybody is through the paper in a public hearing, which was not done. Okay. Last known address of the persons and be notified. And C, notify any person or group filing a written request for notice of the agency rulemaking hearings, such as request of renewed annual in December, basically going on the facts about general laws in Massachusetts. And it goes on and on and on and on and on about this stuff, about how it should be done, how it shouldn't be done, how it should be conducted, and so forth. I'm going to stop this tape reel here, and I'm going to go back on and conduct it on the next one. And I'm going to upload this one on YouTube and keep following out after that.